Several senators are presenting bills in the House today as well. So we're going to start this with Representative, almost called you Senator, Representative Jeff Coleman on House Bill 615. And then we'll move to House Bill 87 next. And for those in the audience, we're going to implement a 4-minute time limit as we have many bills today. Representative, begin when ready.
Thank you, Mr. Chairman and committee. My name is Jeff Coleman. I represent District 32 in Oak Grove, Green Valley, and Buckner. Really appreciate you hearing this bill so quickly, and it is a bill that I've had for the last 3 years. Has become very, very personal to me because I have a child that has gone through some of this. So really, really appreciate you guys. Currently, the way this bill, the way the laws are set up right now, a child under the age of 14 that would otherwise be inadmissible in court, including a visual and audio recording of verbal or nonverbal statement, can be used for someone that is under the age of 14, so they don't have to testify in person. What this bill would do is to raise that age to anyone that is under the age of 18, so 17 and under. It also adds a vulnerable person, a person who has the learning ability of 17 or under as well, so a vulnerable person is also added. It also modifies the enticement of a child by increasing the age of the victim from less than 15 years old to less than 17 years old. The bill modifies the penalty provisions for the offense of a patronizing prostitution. For patronizing prostitution, currently the penalty distinctions are for victims older than 14 years old. And for 14 and younger. This bill increases the age from 14 to 15 years old and modifies the offense of patronizing prostitution if the individual being patronized is 15 years of age or younger, from a Class D, as in David, felony, to a Class B, as in boy, felony. This also puts together a money fund, which is now called the Human Trafficking, and I apologize, I'm losing my spot, I don't have my glasses. The Human Trafficking and Sexual Exploitation Fund, which is run by the the Treasurer's Office. Upon the receipt of the fund money, they then distribute it to the county where the offense took place, and then the county is responsible for distributing that to the department that is taking care of who made the arrest. Half of the funds go there, and half of the funds go to the anyone who is helping the folks that are being patronized. So. That is to help the police departments have more training. It does not require any training, but it allows for them to get more training if they want. It also allows to add more officers and to become better equipped to take care of these issues. It also, the last thing it does is that currently the court collects $46 to be paid to the crime victims compensation fund for a guilty plea or finding of guilt for Class C or Class D felony. This bill adds a class that was not provided in the past by mistake. This bill adds to that a Class E felony to this provision. So with that, I will tell you why this is so important to me. I'll go into a little bit of personal stuff, and I won't be long. My daughter was molested by my son-in-law, not his wife, but his sister-in-law. She was 15, he's 35. I tried to get this in place prior to this happening, and it meant a lot to me then, but now it means a whole lot to me because unfortunately this wasn't in place. My daughter was 15. He pled out for 2 felonies, got 5 years probation, doesn't even have to serve any time, and he does have to register. But had we gone forward and taken this to court, we probably would have gotten a whole lot more time. But because she couldn't do the hearsay part of this, I wasn't going to put her through going in front of him and testifying. So with that, I'll take any questions.
Representative, thank you for attacking this issue again this year. Want to say how sorry we are for what you've gone through as a father and what your family has gone through. But I'm going to open it up to any questions on Senate Bill 615. Seeing none, your first witness, please come forward. Make sure you have a witness form filled out and leave it on the witness stand, and you will have 4 minutes when you start your testimony.
Good morning, members of the committee. Jessica Seitz, Executive Director of the Missouri Network Against Child Abuse. We want to thank Representative Coleman for bringing this bill forward. The issues included in this legislation are a top priority, and they have been for several years. At the heart of this is the recognition that children ages 14 to 17 are that, children. And it expands protections that are currently in our law to this very vulnerable population. They're vulnerable especially to the commercial sexual exploitation of children. This, especially the provisions within 491 and 492 within this bill, those have been used by my child advocacy centers, who I represent, and their multidisciplinary team members to reduce the trauma of appearing in court in front of their abuser multiple times. This inhibits their path to healing, and we're really looking forward to this bill getting over the finish line in 2025. Thanks.
Thank you for your testimony. Any questions? Seeing none. Next witness in support, please come forward.
Thank you, sir.
I think you know the drill. Got the witness form in hand and ready to go.
And Senator, will not take 4 minutes. My name is Darrell Moore. I'm the Executive Director for the Missouri Association of Prosecuting Attorneys and Missouri Office of Prosecution Services. We also want to thank the representative for being persistent. Like he said, we've been trying to pursue this bill for 3 years. I started as a Greene County Assistant Prosecuting Attorney in April of 1983. In fact, on April 1st. I do not think that I was a fool for doing that, and I've had a rewarding career. But when I started in '83, we didn't have the tools that are in 491, 492, and it was very, very difficult to try a child sex case. Then in 1985, the General Assembly passed the beginning stages of this law. So we are here to testify strongly for 491, 492. I have tried over the last 40-some-odd years many child sex cases, and I can't tell you the big difference it makes. And it's not just makes a difference to the prosecutor, the big difference is for the child. It spares them a lot of trauma. Before we had 491, 492, a child could be examined by a children's division worker or another social worker, then a police officer, then a prosecutor. With 491, especially the 492 part and the child advocacy centers now, a child is only really interviewed one time, producing less trauma by a trained person. So we are strongly in support of the 491, 492 part, and as the representative said, when the criminal code revision was passed in 2017, creating a new Class E felony, it was overlooked to include that in the Victim Compensation Fund. We're missing a lot of funds that should be going to victims that deserve to be compensated for the trauma that they've experienced. And we certainly support the rest of the bill, but primarily 491, 492, and the Victim Compensation Fund judgment. Thank you.
Thank you. Any questions? Seeing none. Next witness in support, please come forward on Senate Bill 615. Any further witnesses in support? Seeing none. Moving to witnesses in opposition of Senate Bill 615. Make sure you have a witness form, and you will have 4 minutes.
Thank you, Mr. Chairman, members of the committee. I appreciate your time. Sorry, thank you. In all candor to this committee, I came here to talk about a different bill, but since I heard this one, this is something I feel needs consideration on constitutional grounds, because I completely understand the pull to vote for this. Specifically, I'm discussing the hearsay exceptions in 491, 492. I take no position on the funding.
And just for the record, could you introduce yourself for those
Yes,
listening?
I was just going to get to that. I apologize. TJ Kirsch, Kirsch. I am an attorney here in Jefferson City practicing criminal defense. I'm also a board member for the Missouri Association of Criminal Defense Lawyers. My family has been impacted by child sexual assault. I'm not here to discount anyone's personal experiences, nor to minimize the impact those things have. I am here to emphasize that our constitutional order maintains that the right to confront witnesses is a paramount, substantial right that is part of our right to trial by jury. The notion that increasing hearsay exceptions and therefore diminishing the right to confront witnesses against somebody is fundamentally question-begging. We are talking about the criminal courts. And in the criminal courts, we do not know someone is guilty unless and until a jury of their peers says so. That's where we apply these rules. And I encourage, like I said, I don't have it printed. I wish I did. I encourage the committee to heed Justice Scalia's opinion. It's a dissenting opinion in Maryland v. Craig, which is the case that took this issue up initially in the Supreme Court. And he made the observation, is it not a fundamental part of confrontation for someone to be before the witness accusing them and say, isn't it true that I did not do this? These increasing hearsay exceptions beg the question, they assume guilt from the outset, and they fundamentally diminish Missourians' rights at trial. Thank you for your time.
Thank you for your testimony. Any questions?
Sorry.
Seeing none. Moving to opposition. Any further witnesses in opposition? Seeing none. Any for informational purposes? Seeing none. Closing remarks.
Thank you, Mr. Chairman. While I understand and agree to a certain degree with the last person, when a child has to go through as many things as they have to go through to get to the point of trial, such as a rape test, which takes anywhere from 6 to 8 hours of your day, going through the forensic interview, and they have access to all that. We're talking about children here. We're not talking about adults. So I would beg to differ on that piece of it. I get it for adults, but anybody that is a child, I think that we have to give them some consideration. So I appreciate the opportunity to present this bill today. Thank you very much.
That will conclude the public hearing on House Bill 615. We're going to continue in a subcommittee still, since we do not have a quorum, and we will move to, it's going to be House Committee Sub for House Bill 87. Representative Griffith, please take the witness stand and present when you are ready.
Thank you, Mr. Chair, members of the committee. For the record, I'm Representative Dave Griffith. I represent the 60th District, which is right here in Jefferson City. You know, so often tragedy brings about the need for change. House Committee Substitute for House Bill 87 is a driving while intoxicated bill in its form. I'm going to refer to this bill as Melanie's Law. The bill modifies the offense of driving while intoxicated, and currently the offense is a Class E felony if a defendant is driving while intoxicated and injures someone else. This bill would increase that penalty to a Class D felony. It's a Class D felony if a defendant is driving while intoxicated and seriously injures someone, and this increases that to a Class C felony. Now, if a defendant is driving while intoxicated and causes the death of another person, the defendant is currently a Class C felony, but this bill would increase that to a Class B felony. And if a defendant is driving while intoxicated and causes the death of two or more individuals and has a blood alcohol content or a BAC of 0.15, it moves from and is found guilty as an habitual offender of driving while intoxicated and causes the death of another person. The defendant is now a Class A felony. The person found guilty of driving while intoxicated or acting in a criminal negligence and the death of another person will not be eligible for parole for at least 5 years. If a person is found guilty of the death of two or more individuals and has a blood alcohol content of 0.15 and is an habitual offender, the offense has to do at least 10 years. I filed this bill late last year, and while, in addition to this, when the bill came through the committee and through the House, there was another provision that was added that is for a diversion program for DWIs for first offense. They're not enrolled in a DWI diversion program, and they haven't completed in the last 5 years. They do not hold a CDL, not driving a commercial vehicle, did not injure or kill anyone, did not refuse to submit to a BAC test, and they work it out with the prosecuting attorney. There's an interlock device that is placed on their car and is monitored by the Department of Revenue. But I want to get back to the genesis of this bill. And the family came to me last year. And Melanie Wonkum was a very good friend of mine. And her tragic death had a toll on many of us, but not to the extent that it has and did on her family. On October 22nd of 2022, life changed for many people. Melanie's mother and sister came to my office last year, and we started building this bill. And it began with talking with our research folks in the House, talking with the prosecuting attorney here in Jefferson City, talking with a judge here in Jefferson City. And driving while impaired is a choice that you make, a choice that often causes a tragedy to so many families across the state. House Committee substitute for House Bill 87 it is our hope that this is going to change the actions of many people. And considering that if they know they're impaired, that they will not sit behind the wheel and in tragic cases cause the death of someone else. With that, Mr. Chair, I'd be open for any questions.
Thank you, Representative, for presenting this bill today. It's my understanding that most of these parts we've heard in this committee on several different bills. So with that, if there's any questions, I'll open it up for discussion. Senator May.
Good morning.
Good morning.
Is this for first offense as well?
Yes, for first offense as well, correct.
It's for first offense as well.
Yes,
and
correct.
so is the bill, to my understanding, is making it mandatory that that an individual purchase an interlock system?
Correct.
Okay, thank you.
Yes.
Any further discussion? Seeing none. Moving to your first witness in support, please come forward. You'll have 4 minutes for testimony. Make sure you have your witness form that you can drop off at the witness stand.
Good morning. My name is Tina Ware. Next to me is my mother, Annette Wallace. House Bill 87, Melanie's Law, is named after my younger sister, Melanie Wonkum. On October 22nd, 2022, at approximately 11:37 p.m., Melanie was a passenger in a car that was hit head-on by a drunk driver. My sister's friend who was driving was seriously hurt. My sister was pronounced dead on scene. The drunk driver of the other vehicle had very minor injuries. My sister left behind her 25-year-old son, who is a law enforcement officer with the Callaway County Sheriff's Office. She also left behind her 21-year-old daughter, who is currently attending college at Southwest Baptist University studying criminal justice. She graduated in December of 2023. Melanie was a very hard worker. She managed Theo's Midtown in Jefferson City, Missouri, and was loved by all of her customers and coworkers. My sister and her friend had zero alcohol in their system and were approximately 1 mile from Melanie's home in Jefferson City. The drunk driver was staying at a local hotel, but had been celebrating all day at the Mizzou homecoming football game with his family in Columbia, Missouri. At some point, they checked in at the hotel. It was suggested more alcohol was needed. He then left the hotel in his vehicle, proceeded to Hy-Vee, which was closed, and then across the street to the gas station to purchase some wine. On his way back to the hotel is when the collision happened. According to the Missouri Highway Patrol traffic crash reports for 2022 and 2023, the total amount of fatalities involving alcohol, drugs, alcohol use, or both drugs and alcohol were 209 in each year. I also found a Forbes article dated January 3rd, 2025, which lists the worst states for drunk driving for 2025. Missouri was ranked 9th. I don't think that's a top 10 that we want Missouri to be in. The answer to controlling impaired driving is in making harsher punishments for those involved in DUI incidents, especially regarding DUI fatalities, which is the purpose of Melanie's law. People always think, oh, this won't happen to me or my family. I know I did, and look what happened. In Melanie's situation, this was the drunk driver's first incident on record. During court, it kept being brought up that this was his first incident. I believe Missouri needs to get out of that mindset. We have to take charge with punishments at the first incident in order to prevent other incidents from happening. It could save someone's life. According to the Right Step, which is a Promises behavioral health company, the average drunk driver will operate a motor vehicle 80 times before getting arrested and charged with their first DWI. That's 80 times. DUI fatalities can be 100% prevented. With today's technology, it's too easy to call Uber, Lyft, or a friend, to call DoorDash to have food or alcohol delivered, and then how about just taking the responsibility of having a designated driver? With hopes of Melanie's law passing, I would like to see Missouri make it known how harsh of punishments that a DUI fatality can have. Hopefully it will get people to think twice about getting behind the wheel while they are impaired at any level. I thank you for your time. I want to be involved in positive changes for Missouri in order to keep all Missourians safe. Let's make Missouri a leader for change, not a follower. Change starts when someone makes the first step. We cannot undo what had already been done, but I am hoping this small step will lead to big changes. Thank you.
Was Mom going to testify too? Okay, then you don't need to fill out a witness form then. But are there any questions? Just want to say thank you all for coming today, and we are so very sorry for what you've gone through and your family has gone through.
Thank you for your time.
Thank you. Next witness in support of House Bill 87. Yeah, as of right now, we're gonna pause. You can still sit down and prepare. We're going to move out of a subcommittee and into the regular committee structure. We're going to take roll. Mr. Secretary, please call the roll.
Senators Schroer.
Here.
Gregory 15. Brown 26. Here. Coleman. May. Here. Roberts. Here. Schnelting.
All right, having a quorum, we will now go back to the regular hearing on House Bill number 87. Whenever you're ready, please begin.
All right, good morning, Mr. Chairman, members of the committee. My name is Heather Elder, and I serve as the Victim Services Specialist for Mothers Against Drunk Driving, also known as MAD. I am here to express MAD's support for House Committee substitute for House Bill 87. I represent, sadly, thousands of victims and survivors who have been impacted by drugged and drunk driving. This legislation represents a very critical step forward in MAD's ongoing efforts to reduce the devastating impact of impaired driving in Missouri by strengthening Missouri's laws. This comprehensive bill is a long-awaited step forward in our collective efforts to identify room for improvement in current laws. Specifically, number one, it strengthens administrative punishments. Number two, it implements stronger technology-based tools for those convicted of driving impaired. Number three, it creates a diversion program that addresses specific offenders, first-time offenders, who have the greatest chance of behavioral change through ignition interlocks in conjunction with victim impact panels. Studies show that when combined, technology countermeasures like the ignition interlock and victim impact panels further decrease recidivism. Honoring Melanie Wankham today through this law and honoring so many more victims by increasing the level of felony should a person cause the death of another by driving impaired is what is behind Melanie's law. While MAD believes taking a life after making the choice to drive impaired should be charged with the highest possible class of felony, the change this bill brings better aligns Missouri with other states, and it is a positive step in the right direction. It should be noted that every 39 minutes across the United States, someone is killed by an impaired driver. 39 minutes. Imagine if the entire population of Poplar Bluff, Festus, Branson, Sykeston were to be simply wiped off the map. Over the past 45 years, that's the number of those who have been killed on Missouri roadways due to this 100% preventable crime. These are our citizens, our friends, family members being killed every year. In Missouri, over just the last 10 years, 41,097 people have been either killed or injured in an impaired driving crash, according to the Missouri State Highway Patrol STARS crash reporting system. What that means is 11 people are killed or injured every day in Missouri over the last 10 years. It is time to toughen the laws. By reducing the instances of impaired driving, Missouri can collectively prevent the tragic loss of life, the emotional and financial burdens that victims and families and the state must endure following a crash. House Committee substitute for House Bill 87 represents a proactive approach to safeguarding our communities and ensuring that fewer families experience the heartache associated with impaired driving, such as Melanie's family has had to endure. This bill offers a balanced approach that prioritizes prevention, accountability, enforcement, and rehabilitation. By supporting this bill, we have the opportunity to make a significant impact on the safety and well-being of our communities. I urge you to consider the long-term benefits of this legislation and to please join MAD in its commitment to ending drunk and drug driving. Thank you for your attention, and thank you for your dedication to creating a safer Missouri for all of us.
Thank you for your testimony and your advocacy on this issue. Are there any questions for the witness? Seeing none, we're going to move to the next in support of House Bill number 87. Reminder, you will have 4 minutes, and drop your witness form off on the witness stand.
Good morning, Chair, members of the committee. My name is Chase Glasser. I'm with the SAFE Coalition. We seek to expand access to life-saving technology, particularly ignition interlocks. We are in support of this bill. Really just wanted to avail myself if there were any questions about the technology, any technical questions that we could assist with, and state our support for the bill.
For the record, could you repeat your name?
My name is Chase Glasser.
Okay, thank you.
Yes, sir.
Any questions for Chase? Seeing none.
Thank
Moving to the next witness in support of House Bill number 87. Next witness in support of House Bill 87. Seeing none. Moving to those that are in opposition of House Bill 87. And make sure you'll have another witness form. You know the drill.
Thank you again, Mr. Chairman, members of the committee. I understand the efficiency this morning and the time constraints, so forgive me, but I'll try to be efficient. When it comes to first the increased administrative punishments, for lack of a better word, administrative retribution, specifically the increased demands on ignition interlock, I would just like to point out that while the statute would limit that to a certain blood alcohol content that is 0.15, I believe. It's still a significant increase in the administrative consequences of a DWI, even if that is a first offense. Many constituents have one offense and they are not habitual. They do not turn out to be chronic, cause accidents, things of that sort. So I would like this committee, or I would ask this committee to consider the wisdom of increasing an administrative toll on a first offense with, for example, no accident, no injury, no other aggravators like that. I'd also like to highlight this diversion program. While in a vacuum diversion makes sense, I see two issues with diversion here. First, diversion's already been codified in 557-014, and as I'm sure this committee and the legislature heard when discussing that diversion program, prosecutors already have virtually unbridled authority for diversion. So here we have an additional diversion program which may in some circumstances conflict with a pre-existing diversion program under 557. All the while, prosecutors have this authority nearly unilateral to begin with. So I'd ask you to consider that. The time frame for this diversion program as well, I see can cause some issues in that it might effectively, or at least as written, incentivize refusals. And by refusals, I mean a refusal to submit to chemical testing. If I can. Specifically, I am on page 15 of the bill, lines 15 through 18. It says the person may submit a request to the prosecuting attorney and send such a request to the Department of Revenue within 15 days of his or her arrest. A lot of folks don't know who the prosecuting authority would be within 15 days. A lot of cases aren't filed within 15 days. Even here in Cole County, the prosecuting authority may be a municipal prosecutor or the prosecuting attorney's office here in Cole County. That can only be exacerbated in places like Kansas City, St. Louis County, where you have 15 days to send a request, but you don't know to whom to send that. However, you can extend that by refusing the chemical test. So I'd ask the committee to consider that as well.
And even though your time has expired, I'll let you kind of briefly summarize. And
It's been 4 minutes already.
it's been 4 minutes. And can you, just for the record, there are some listening at home, just reintroduce yourself. So
Did I forget to do that again? I apologize.
It's early. It's fine.
TJ Kirsch. I'm an attorney here in Jefferson City, practicing primarily criminal defense, also appearing here for the Missouri Association for Criminal Defense Lawyers. The diversion program adds cases to dockets both for the courts and the Department of Revenue. Both, I'm sure this committee is aware, are very burdened. And finally, and we have discussed it in this committee before, I am sure a lot of constituents have shared their concerns that ignition interlocks can cause issues, headaches, even when the person is not drinking, with false positives, with locking them out of their vehicle, things of that sort. I thank the committee for your time and welcome any questions.
Any questions? Seeing none. Next witness in opposition. Seeing none. Any for informational purposes? Seeing none. That will conclude the public hearing on House Committee set for House Bill 87.
Mr. Chairman?
Yes.
May I approach again just for informational purposes very briefly?
It has been closed.
Fair enough.
So we're going to move to House Committee sub for House Bill 1259. I think I said there he is. Representative Hardwick, please come forward on House Bill 1259.
Good morning. Thank you, Mr. Chair, members of the committee. My name is Bill Hardwick. I'm House District Rep for District 121, presenting House Committee substitute for House Bill 1259. House Bill 1259, at the essence of it, is a trust taxation bill that just seeks to bring fairness and sort of tax parity for domestic trust. So right now in the law of Missouri, if there's a trust that was formed outside the state of Missouri, it's taxed in Missouri on its income in Missouri, but not on its income in other states. But if there's a domestic trust formed in Missouri, it's taxed on its income in Missouri and other states. And this bill just makes sure that trusts formed in Missouri have the same tax situation, the tax benefits as trusts formed outside Missouri. On the floor, some other provisions were added, including electronic wills, allowing the witnesses to sign electronically, to be recorded electronically, and the intent of the testator to be considered by the circuit clerk. A bill was added that required a title search for assets to be moved into a trust. A new associate circuit judge for the 26th Judicial Circuit, a new circuit judge for the 25th Judicial Circuit, which the bill sponsor indicated to me that was consistent with the workload study, and that there was money in the budget that correlated with those circuit judge authorizations. The mirror law that said that individuals who are incarcerated, their assets cannot be seized to fund the housing while they're incarcerated. So under Missouri law now, 10% of that cost can be taken to cover 90% of the cost of the time in DOC. Under this bill, the state would no longer be able to seize the assets of inmates and use their assets, their home, real estate, or whatever to pay for their incarceration. And then there was a provision that changed the requirements for 96-hour holds, that the affidavit wasn't required if it was the doctor or a police officer. And that's the bill kind of its entirety. It did vote out of the House 152-0. There were no votes. In consideration for House Committee sub, I think the committee may want to look at the 96-hour holds. I definitely don't want it to be any easier to civilly commit somebody. I think there's a due process issue. If anything, I think you should make it harder to civilly commit somebody. Just look at that. Maybe don't change the rules, and then just hopefully make this bill something that the entire Senate can think is good law, especially the electronic wills portion, and the essence of the bill, which is important to me, which is creating tax parity for domestic trusts that are formed in the state of Missouri. And with that, I'll yield for any questions the committee might have.
Thank you for your summary of House Bill 1259. Are there any questions? Seeing none, first witness in support, please come forward. You'll have 4 minutes. And make sure you leave your witness form as you're doing now. Thank you.
Thank you, Mr. Chairman, members of the committee. My name is Paul Vogel. I'm an attorney in St. Louis, Missouri, and past chair of the Missouri Bar Taxation Committee, although I must put on the record, I am not here speaking on behalf of the bar. I'm here to talk about literally 2 sentences in the first 2 pages of this bill, which was the original purpose of 1259 to basically put non-resident Missouri trusts and resident Missouri trusts on the same footing. Missouri has some of the best trust laws in the state of Missouri, thanks to this body and the bar. However, our taxation system hasn't kept up with the rest of the country that is attempting to attract this fiduciary business where trust administration drives revenue in a state, employs professionals, whether it be lawyers, banks, trust companies, individual trustees, investment advisors. At the moment, in the year 2000, Boatman's Bank, which was a wonderful bank in Missouri, was acquired by Nations Bank out of North Carolina. And North Carolina wanted to move the administration of all trusts from their trust company from North Carolina to Missouri because of our trust laws. However, Missouri had a tax provision that was unfavorable. And in a piece of legislation that passed in August of 2000, a simple change was made that non-resident trusts will only be taxed on their Missouri-sourced income. Missouri-sourced income means income from Missouri business or Missouri real estate. That's the definition under our code. And since then, a lot of non-resident trusts, including clients of mine, have moved their trust to Missouri, availed themselves of Missouri banks, Missouri trust companies, Missouri professionals like myself. However, at the same time, our residents, our own residents who create the same trusts, don't benefit from the same tax structure. For those clients of mine that are Missouri residents that want to benefit from using long-term trusts, I send them to Tennessee or South Dakota or Florida or Nevada, who have proactively attracted this type of business. So all we're trying to do with the tax provisions in this bill is put Missouri residents who choose to do estate planning for their family and benefit their children and grandchildren on the same tax footing as people from other states that choose to come to Missouri and avail themselves of our laws. That's the entire purpose of the tax provisions of this bill.
Thank
Can I
you
answer any questions?
Yeah, thank you for your summary on that. Any questions? Seeing none?
Thank you for your time.
Thank you. Next witness in support of House Bill 1259, please come forward.
Mr. Chair and members of the committee, my name is John Chalice. I'm a practicing attorney in St. Louis, and I also have the pleasure of serving as the chair of the Probate and Trust Division of the Missouri Bar. I'd like to speak to a couple of provisions in House Bill 1259. I believe Mr. Vogel did a very nice job speaking on the tax provisions, but I want to speak on the electronic wills and other provisions that are in this bill, and specifically it's the portion of the bill that begins on page 3 with the slight change to section 108 of the trust code and continuing through page 12, which concludes at section 474-600. These are four legislative priorities for the Missouri Bar. As Mr. Vogel mentioned, Missouri has always been a leader in trust and estate law, and it has been a great economic driver for this state. These four provisions, which have all come before this committee before in both 2023 and in 2024, have passed out of this committee in the past in Senate Bill 897 and 1221 last year, as well as Senate Bill 72 in 2023. These are not controversial provisions. Every time they've come before this committee or any other committee in either side of this building, they have passed out unanimously. The largest chunk of this deals with electronic wills, and that provision started from the Uniform Electronic Wills Act, and then we essentially conformed that to existing Missouri law. And essentially what this would allow is the electronic execution of estate planning documents in the state of Missouri. We've kept all of the other existing requirements of Missouri law as it relates to the execution of estate planning documents, but this does permit the electronic execution of those documents. And then there's a companion provision that begins on page 9, section 474-600, and this is essentially a cleanup provision that relates to estate planning documents that were done during the COVID pandemic under the governor's executive order. And there's some question as to whether the governor had the authority to be able to change the statute of wills and allow for remote execution. So this statute essentially authorizes that those documents be considered official estate planning documents if there's an affidavit of the scrivener that is added to those. As I mentioned, this has enjoyed broad support on both sides of the Capitol, and it passed out of the House as part of House Bill 1259, 152-0. The time really to do this in order to keep Missouri competitive in the trust and estate law world is now. Every year that we don't continue to update our trust and estate laws, we fall further and further behind other states. These are great economic drivers, both for businesses as well as providing clarity to Missouri attorneys, citizens, and the courts. And with that, I'll take any questions.
Yeah, thank you for bringing that up, that most of these provisions in here we've seen in this committee for many years, and I think some of these provisions I've even seen when I was in the House on Judiciary. So with that, any questions? I think Senator Mays said you did a great job. Okay. So she had to leave to go down to appropriations. But we're going to move to further witnesses in support of House Bill 1259.
Mr. Chairman, gentlemen on the committee, my name is Andy Briscoe. I'm the registered lobbyist for the Missouri Bar. We'd like to thank Representative Hardwick for allowing Representative Parker's underlying bill regarding the trust provisions onto his bill, and we'd like to go on record as supporting this.
Perfect. Any questions? Seeing none.
Thank you.
Next witness in support.
Chairman Shorter and members of the committee, Thank you for the opportunity to testify today. My name is Craig Parker. I've been an estate planning attorney for 25 years. In California, I'm currently the assistant in-house counsel for Trust and Will, one of the nation's leading digital estate planning companies. Trust and Will serves customers in all 50 states, including Missouri. Our platform is especially valuable to individuals living in rural areas and places where they don't have as much access to maybe attorneys and legal services. As they also help our military personnel who may be overseas. By providing accessible and affordable and user-friendly solutions, we empower Missourians to take control of their legal futures and protect the people they love. I'm here to express Trust and Will's strong support for House Bill 1259, which among other important provisions would establish the Missouri Electronic Wills and Electronic Estate Planning Documents Act. This legislation explicitly authorizes the use of electronic signatures for wills and other key estate planning documents, such as trusts, healthcare directives, and durable powers of attorney. House Bill 1259 fills a critical gap in Missouri's current legal framework and reflects a much-needed modernization in the estate planning process. Today, only 1/3 of Americans have an estate plan. A major driver of this reality is lack of access. When individuals are unable to complete essential estate planning documents, their families often face unnecessary legal and financial burdens in probate court. House Bill 1259 helps solve this problem by reducing those burdens, saving families in the state both time, money, and ensuring that Missourians' final wishes are honored, all while easing strain on the judicial system. Importantly, this legislation aligns with the Uniform Law Commissioner's Uniform Electronic Estate Planning Documents Act. To date, 14 jurisdictions, including Indiana, Florida, and Idaho, have enacted similar laws, and nearly half of all states have introduced related legislation. This growing national momentum highlights the urgent need for Missouri to modernize and standardize digital estate planning. Missouri has already shown leadership in this area by passing Remote Online Notarization Act during the COVID-19 pandemic. House Bill 1259 builds on that progress. It represents the next logical step in ensuring that Missouri's legal infrastructure keeps pace with evolving technology and meets the needs of today's families. For these reasons, I respectfully urge the committee to support House Bill 1259. Thank you for your time and thoughtful consideration. I'd be happy to answer any questions.
Thank you for your testimony. Are there any questions? Seeing none. Next witness in support of 1259. Seeing none. Any in opposition of House Bill 1259? Seeing none. Any for informational purposes? Seeing none. Closing remarks.
Thank you all for your consideration. Thank you, Mr. Chair.
That will conclude the public hearing on House Bill 1259. Now moving to the last House bill. I heard this is save the best for last. I don't know if that's true or not, but we're going to move to Representative Williams on House Bills 971, 293, and 978. And I'm going to hand the gavel over to Senator Brown briefly, and I will be back after a couple meetings. You can proceed when ready.
Good morning, committee chair and chair members. My name is Cecily Williams. I'm a representative in District 111, which is the western portion of Jefferson County. And I'm here. I just presented a very emotional bill over in another committee, and so I'm going to try to do this as best as I can here. But House Committee Substitute for House Bill 971, 293, and 978 creates the offense of unlawful tracking of a motor vehicle. So currently, 1 in 4 customers who purchased GPS tracking devices had a history of domestic violence offending. I'm a domestic abuse survivor. I have endured some terrible abuse over many years. I am no longer in that situation, but I was controlled and manipulated by GPS tracking on my personal vehicle by my first husband. And the state of Missouri has 0 statutes for someone placing a GPS tracking device on any vehicle, even if they do not own that vehicle. And about 65% of all murder-suicides involve an intimate partner, and 96% of those victims are female. Missouri ranks third in the nation for domestic violence situations. And what this bill does is it will, like I said, establish the offense of unlawful tracking when the person commits, knowingly installs, conceals, or otherwise places an electronic tracking device on a motor vehicle without the consent of all owners of that vehicle. There are carve-outs for insurance companies for drive safe and save situations, any type of rental vehicle, any type of like buy here, pay here type places that would require a GPS tracking on that. This is really to help with the manipulation and control whenever one owner may not know that there's a GPS tracking device on their vehicle, and or two or three, whatever it might take. My particular situation, I was going to get an oil change, and the technicians noticed that there was a GPS tracking device under my vehicle. And they decided to do a little bit more research and found that there was a second one placed in the engine compartment also of my vehicle. So if one was found, there would still be a second to control. Now, this was many, many, many years ago, but there are so many ways to track vehicles now that you don't contribute to voluntarily through Apple AirTags or, other GPS aftermarket units that can be installed. There are also, if you as a parent at your discretion decides to put a GPS tracking device on a vehicle that your child drives, that also is carved out for this particular bill. The offense of unlawful tracking on a motor vehicle is a Class B misdemeanor, but the second charge would make it a felony. And it doesn't have to be on that specific situation. It's that person who commits a second offense then would get that felony charge. Since there aren't any laws that protect your vehicle from being tracked at this moment. At this time, I'll take any questions that you might have.
Thank you, Representative. Your story is so compelling. I appreciate you sharing it. Any questions for the representative?
Thank you, Mr. Chair. Representative, thank you for bringing this bill forward. When I was in the House, I sponsored this legislation as well. I really appreciate your efforts on this and Representative Strickler's efforts. I know he's been talking to me about it for several years, and so I appreciate you guys bringing it forward. I think it's a much-needed thing. And I also appreciate you sharing with me on the House floor just recently your personal story. So I look forward to getting this passed. Thank you so much. I appreciate that.
Any other questions for the representative? Seeing none. First witness to testify in favor of House Bills 971, 293, and 978. Please proceed when you are ready.
Thank you, Mr. Chair, and thank you, members of the committee. My name is Kemp Strickler, State Representative in House District 34 in Lee's Summit, and I very much appreciate your hearing this bill today. I did file this bill, or a different version of this bill, 2 sessions ago. And I did that based on a constituent story that someone, when I was first running for office, someone in my district said that their girlfriend, their partner, they found their vehicle being tracked by an ex-boyfriend without their knowledge, of course. Now and they were fortunate that they found that before the situation turned more tragic, that kind of thing. But this is happening so frequently. The more that I dug into the issue, the more I learned about it, the more I found where people were being tracked without their knowledge, leading to, unfortunately, truly devastating consequences. In 2022, Sarah Beck of Belton, Missouri, and Mikey Williamson of Lenexa, Kansas, were killed when an ex-boyfriend of Ms. Beck's tracked her with a GPS device and then murdered the two of them before taking his own life. The ex-boyfriend had set up a geofence that would automatically notify him when she showed up at work, when she showed up at her friend's house, and at her home. And you'll be hearing testimony later on from Mikey Williamson's mom. Fortunately, not all situations turn this tragic, but with the low cost, with the prevalency of this tracking technology, these instances are just occurring way too frequently. I had a couple folks from domestic violence shelter in Kansas City that were advocating with me just last month on separate issue, and we just started talking about this bill. And they said they'd had a client of theirs just the week before, so we're talking about late February, that they'd talked to. That client had arrived to their office to get a protection order, and she started being bombarded with texts from her abuser saying basically that, asking why she left work early, threatening her, saying, I know where you're at now. And the client, had stated this wasn't the first time they'd done this, that she believed there was a tracker in her car, but they couldn't find it. Eventually, her adult son found it, but again, the cost of this is just, it's way too affordable, and the ability to have covert ways to hide these trackers. I had no idea when I first started this process, but there are companies that very intentionally try to hide these trackers. These devices have been used to track small business owners, to track their vehicles so that they can rob them, especially ones that are cash-heavy businesses. They've been used to track people when they leave their homes so that they know when their home can be burglarized. And for those of you who were here back in 2020, you may remember a situation where a state legislator actually helped a private investigator place a tracking device on vehicles driven by a staff member of Governor Parsons' staff and one of his cabinet members. So it's far too prevalent. There are many legitimate uses for the trackers, and I believe, as Representative Williams said, we believe we've addressed the legitimate uses for these things. But we do need to provide law enforcement with a tool that helps them intervene before these situations escalate to where it turns tragic. Thank you so much for hearing this bill, and I'd be happy to take any questions.
Thank you for your testimony. Next, any questions? Seeing none.
Thank you.
1 second. Senator May.
I have a question. So what about, I was reading the bill, and most of it is around relationships. So how do we deal with an individual who, say, for instance, can go to the fence, I dropped my keys or I left my keys inadvertently, or they drop down the side of the vehicle. It might have one key on it or two keys, but it has an air tag attached.
An air tag attached.
You get me? So how do we, deal with that argument when, or how do we enforce it when you got that argument? Because people are slick.
Yeah, I think, do you want to? I think that's, that can be a challenge. I think still, we're talking about all owners needing to have consent for this kind of thing. If Representative Williams.
Thank you. So this is really for the malicious intent. So if you're in your brother's car and you drop your keys and you don't realize until you get to your car that they're in there, he knows that you have zero malicious intent with that. What this bill does is it protects people who might be traveling in a vehicle, say myself, being a domestic abuse survivor. One of the ways that my first husband controlled me was by placing a GPS tracker. I didn't know it was on there. Now you're talking in the mid-2000s, 2006 to be exact. We have a lot better technology now, better ways to find out if a vehicle is being tracked. But I was ran off the road. I live in rural Jefferson County. There were cliffs. It was very dangerous. His intent was for me to no longer be able to care for my children, and that's why he placed the tracker on the vehicle. We have to prevent that. I did not know I was being tracked, but all owners, and then so that establishes that even though you're the owner of that vehicle, you can't lawfully track your spouse, especially if you're in an abusive relationship. All owners need to be aware of that. And it creates the first offense is a Class A misdemeanor, and the second is a Class E felony. So we know that abusers, in my specific situation, they don't care that they're breaking the law, but knowing that you have the recourse to say, I will press charges, I am going to press charges, and you have that to back up your claim, will and can deter somebody, because they don't want to be uncomfortable. They want you to be uncomfortable. That's why they manipulate and control you.
Absolutely. Thank you.
You're welcome. Thank you.
Further questions? Seeing none.
Thank you.
Thank you. Next witness in support, please come forward. And for the committee members, we will be going into executive session after this bill before we go to the 3 Senate bills. You can proceed when ready.
Good morning. I'm Bill Irwin, representative of the 55th District, which is in Cass County and includes a little bit of Lee Summit. When Representative Strickler first brought this bill to me to check out, I read it and said, wow, this is a common sense bill. How could anybody be against it? My opinion is based on being a retired Lee Summit police officer and a retired military member who has firsthand knowledge of the evil that stalkers can present. One of my assignments in the military was deploying to Pakistan as the liaison officer to the U.S. Embassy for SOCCENT, Special Operations Command Central. To complete this mission set, I needed to work closely with all elements within the U.S. Embassy. One young diplomat I worked with closely was a powerful, intelligent young lady who could knock down diplomatic and bureaucratic doors like a Navy SEAL breaching the door of a bad guy's house to complete the mission set. Unknown to me at the time, one of my military co-workers had a crush on this young lady, and or young diplomat, and she had rebuffed his advances. During her stay in Pakistan, as all diplomats do, they get a chance to take vacation, and she decided to come back to the United States on leave. My military co-worker found out she was returning to the States and took emergency leave to get to the States before she did. In the States, he tracked her trip home. Fortunately, law enforcement had been apprised of the situation, detained him at the airport, where they found in his possession a body bag, duct tape, flex cuffs, cutting knives, and a saw. The evidence of the co-worker tracking this young diplomat was used to help to prosecute him and send him to jail. As a retired police officer, I cannot tell you how many times I have seen jealousy or domestic violence situations incite people to do the things that will shock the conscience. This anti-tracking bill is not an end-all, be-all to prevent violence, but it's a great tool for my brothers and sisters in law enforcement, which they can use to protect the vulnerable. Perhaps just by helping the vulnerable gain an ex parte or a full order of protection in order to break the cycle of violence. I highly encourage the Senate to pass this bipartisan legislation, and I'll be happy to take any questions.
Thank you, Representative. Are you one of the bill numbers on this bill string, 971, 293, 978?
I am, sir.
Okay, which bill number was yours?
293.
Perfect. Any questions for the representative?
Oh, 978, that's right.
978.
Sorry.
All right, seeing none. Moving to the next witness.
Good morning, and thank you for allowing me the opportunity to share my story. My name is Melanie Williamson, and I'm here to share my story about my son Mikey and his friend Sarah. On the night of February 27th, actually the early morning hours, my husband and I went to bed, and my son came in a little after midnight and said goodnight, closed our door. I'm like happy he's safe in a home. And a short time later, I woke up to gunshots. My son's room was right next to ours. I woke my husband up and I said, were those gunshots? And then as soon as I said that, another gunshot was fired, and it came through our bedroom wall and shattered our window. And at that point, I went to my son's room and I opened the door, and I saw Sarah lying on the floor, and she was killed instantly. I saw the murderer at the end of my son's bed, and he was slumped over. He was still breathing. He had shot himself, and that was a bullet that came through our wall. And I looked at my son, and he had a bullet hole in his temple. And I walked to him, and I tried to wake him up, and I did wake him a little. And he was able to tell me what happened, barely. And called 911, and soon enough, about 6 policemen were running up my stairs with guns drawn. They asked me to leave the room. We ended up following the ambulance to the hospital, and I watched my son take his last breath at about 6 o'clock that morning. I'm sorry, I'm trying to keep it together here. This happened because this 37-year-old man came into my home because he had a tracker on Sarah's car, and he had terrorized her with it. My son had just met her 2 weeks before. He did not know this man from Adam. Dustin Johnson was his name, and we found out later that he had come to our home a week before because he was able to. We had seen footprints in the snow leading up to our back door, which is where he came in our home, and then leading out, and he had jumped over the fence, and so he staked out our home. And that night, he sat in his house in Belton, Missouri, and he got notification on his tracker system that Sarah was at our home, and he put on his tactical vest and his 2 pistols and a big, huge knife and an AK, which I have heard of so many other instances where the outcome has been the same, whether it's rape or murder, and I believe that this bill will help prevent some of those, and I appreciate everything that you have done and everyone, and I appreciate being able to tell my story, and I just hope and pray that you guys can understand how dangerous these things are, and this is a first step to doing something about it. And my son was 20, Sarah was 23. They had their whole lives in front of them. They were great people. I cannot explain to you the impact that this trauma has had on so many people. It's just destroyed lives. So. Again, thank you for your consideration. I really appreciate it.
Thank you for your testimony, and on behalf of the committee, we're very sorry that your family and Sarah, was that her name?
Yes.
Sarah's family had gone through this, and we're going to do our best to try and craft something that will prevent this from happening again.
Thank you so much.
Any questions? Senator Brown.
Well, I just want to echo what the chairman said, and I think everyone up here that's children of their own, you really reflect when you hear a story like that. And had I been through the same scenario that you had, I do not know that I would have the courage to be sitting up here sharing that story in front of a Senate committee. So I want to thank you and just give you my assurance that I'll do anything in my capacity as a legislature to help prevent something like this from happening to someone else. So you being here does make a difference, and I'm grateful for it.
I appreciate that.
Any further questions? Seeing none. Moving to the supporting witnesses, please come forward. You'll have 4 minutes. And by show of hands, who else is here to testify in support of this bill? Any in opposition? Informational? Okay.
Good morning, Senators.
Good morning.
I'm Nick Brand. I've been the attorney for Melanie Williams' family and Sarah Beck's family for over 3 years, going on 3 years now. We have pursued litigation against the tracking device companies, and through that litigation, I've learned some things that I think are important for you to hear today, in detailing why this bill is so important. First of all, Sarah Beck, a Missouri resident, she went to police several times. She knew she was being followed, and she went to police. They were unable to help her because she couldn't fit under the umbrella of the stalking laws that are currently in the state of Missouri. Had this bill been in place, had they could have simply looked for a tracking device, found a tracking device, and arrested Dustin Johnson, Melanie's son might be here today. Sarah Beck might be here today. This is an important tool for law enforcement to be able to look for these devices and not have to look at other things outside of simply being followed in order to detain these individuals so that tragedies like this don't happen. It is also important to bring attention to the dangers of these devices. The device that was used in Sarah Beck and Mikey Williamson's case was a covert GPS tracking device, not an AirTag. An AirTag's Bluetooth device, that's different. A covert GPS tracking device emits no signals, is undetectable, could be under any one of our cars right now without us having any idea. I have a daughter. That scares me. I have women in my life. That scares me. But it should scare more than just the women in your lives, because through this litigation, we've uncovered over 25 murders and attempted murders since 2021 involving these types of devices, just in the United States. We're aware of robberies where business owners are targeted for ambush in order to take their cash. We're aware of kidnappings. We're aware of all sorts of crimes because these devices are so undetectable. The way they work is they communicate with an app on your phone. That app on your phone will reload every 30 seconds, giving you live updates on Google Maps as to where your victim is going and where they are traveling to. It allows you to set geofences so that you have patterns. You can see when people leave and enter zones. These devices are far more dangerous than is in the public zeitgeist, and I think it is very important for Missouri to take the step to prevent them from being used against people, unsuspecting victims, not just domestic violence victims, any types of victims. Through our investigation of this litigation, or investigation and litigation, we have learned of them being used against judges who made rulings that litigants didn't like, legislators, social media personalities, beyond that, just business owners and random people whose customers have used them to stalk people because they're cute. This issue is much more wide-ranging than the legislation in front of you. And it's important to understand that this tool needs to be in the belt of our law enforcement agencies and needs to be stressed how important it is in order to keep these things from happening, like what happened to Melanie Williams. Thank you.
Any questions? Seeing none. Next witness in support? Seeing none. Next witness in opposition? Seeing none. Informational purposes, please come forward.
Good morning, Mr. Chair, members of the committee. I'm Brandon Koch here on behalf of the Missouri Insurance Coalition, just testifying for informational purposes only. We appreciate what the sponsors are trying to accomplish, and they're very willing to work with us, the insurance industry, to carve us out of this bill for voluntary telematics devices. So there are a number of our member companies will offer discounts based upon the way you drive. If you're accelerating hard, turning hard, things like that would work against you, but if you're just cautious and you drive in moderation, there are benefits for that. So We have nothing to do with what they're trying to accomplish. As a Missourian, I completely support it and are just happy to, and thankful that they allowed us to get out of the way.
Any questions?
Quick question.
Senator Gregory.
Is the language you want in here? It's in here?
Yeah, yes, it is.
Okay. I was going to say, because if you're installing this device without consent, I'm assuming you get consent.
I think we're sub 8 on the last page.
So you're specifically cutting yourself out, but on top of that, I don't see how you'd fit under this anyway, because you're getting the consent.
So in some instances, if you have lien holders, one of the bills talked about all parties, and we didn't want to get caught in some type of a
Very
loophole.
good. Thank you.
Sure.
Any further questions? Seeing none. Next witness for informational purposes. I thought I saw another hand for informational purposes. I think Brandon was so thorough that he just took care of that. No further witnesses. Any closing remarks?
I just thank you for your time and the understanding of how important this situation is. Thank you.
That will conclude the public hearing on House Bills number 971, 293, and 978. I now move that we go into executive session. Do I have a second? Having a second, we are now in executive session. I now move that we bring Senate Bill 589 before the committee. Do I have a second? Having a second, we are now before the committee on Senate Bill 589. This is the civil actions on sexual abuse and statute of limitations presented by Brad Hudson, Senator Brad Hudson, last week. It is my understanding that there may be some compromise language that they're going to roll into a floor sub, but we're going to move these bills out of committee as promised. It was not a joint bill, but it was presented along with Senate Bill 590 as well, which we're going to vote out. I think the ultimate compromise will bring those two bills together in a floor sub, though. Any discussion? Seeing none, I renew my motion that we vote do pass Senate Bill 589. Mr. Secretary, call the roll. Do I have a second? We have a second. Call the roll.
Senators Schroer.
Aye.
Gregory 15. Aye. Brown 26. Aye. Coleman. May.
I'm here. Oh.
Aye.
Yeah.
Roberts. Aye. Schnelting.
6-0. By a vote of 6-0, the motion carries for Senate Bill 589. I now move that we bring up Senate Bill 590. Do I have a second? Having a second, Senate Bill 590 is now before the committee. I now move that we vote do pass Senate Bill 590, which is on NDAs presented by Senator Hudson last week as well. Is there any discussion?
We need a second on that to bring it to motion. Okay.
All right, Mr. Secretary, call the roll.
Senators Schroer.
Aye.
Gregory 15. Aye. Brown 26. Aye. Coleman. May. Aye. Roberts. Aye. Schnelting. Aye. 5-1.
By a vote of 5-1, motion carries on Senate Bill 590. I now move that we bring Senate Bill 378 by Senator Mosley before the committee. Do I have a second? Having a second, the motion or the bill is before the committee. I now move that, any discussion on Senate Bill 378. This is on the ombudsman for the Department of Corrections. Senator Mosley's bill last week, which would create an ombudsman to review the actions of the Department of Corrections and work with offenders and victims. Any questions? I now move that we vote do pass Senate Bill 378. Do I have a second? Having a second, Mr. Secretary, call the roll.
Senators Schroer.
Aye.
Gregory 15. Aye. Brown 26. Aye. Coleman. May. Aye. Roberts. Aye. Schnelting. Aye. 6-0.
By a vote of 6-0, the motion carries on Senate Bill 378. I now move that we exit executive session and go back into the regular hearings on the Senate bills. Do I have a second? Having a second, we are now moving into Senate Bill 691 from my good friend Senator May. Senator May, you'll have 30 seconds to present your bill. All jokes aside. Whenever you're ready. Senate Bill 691, then we'll move to Senate Bill 718, and then last... You should be nice to me, Senator. It is April.
691.
Yeah. I believe Senator Bratton will be here for those going to testify on 794. He'll be here shortly. Senator, whenever you're ready.
Thank you. For the record, I'm Senator Carla May, representing Missouri's 4th Senatorial District. This bill mandates the redaction of home addresses of parties, victims, witnesses, and attorneys from all public records and the state court automation case management system. This measure directly addresses concerns about privacy and safety, as public access to these addresses can lead to intimidation or harassment. By protecting sensitive information, we can help reduce the risk of retaliation against witnesses and victims, encouraging more individuals to come forward in criminal cases. Ensuring confidentiality helps build trust in our judicial process, showing that we prioritize the safety and rights of all individuals involved. This bill aligns our practices with other jurisdictions that have successfully implemented similar confidentiality measures, demonstrating a commitment to modernizing our legal framework. Some may worry about the implications of redacting information on public access. However, it's essential to balance transparency with the need for safety and confidentiality. The judiciary still retains the necessary oversight to ensure that justice is served without compromising individual privacy. Senate Bill 691 represents a significant step forward in protecting vulnerable individuals within our judicial system. It acknowledges the realities faced by witnesses and victims and provides the necessary tools for courts to maintain their safety and confidentiality. I urge the committee to support this important legislation to ensure that our court system is both just and safe for all participants. I ask for your support in moving Senate Bill 691 forward. Together, we can strengthen the integrity and safety of our justice system, ensuring that it serves everyone fairly and securely. Thank you.
Thank you, Senator. Are there any questions for Senator on this bill? Senator Gregory.
Senator, just want to say thank you. This is a simple situation because when we file lawsuits, we've already got to file this confidential sheet. You're simply adding a few more restrictions, so it's easy to comply with. Thank you. I think it's a great bill.
Thank you.
It's a little bipartisan love in the air today in April. Any further questions? Seeing none, first witness in support, please come forward. Any witnesses in support? Seeing none. Any in opposition? Seeing none. Any for informational purposes? Seeing none. Senator, closing remarks.
Thank you.
You are welcome. That will conclude the Senate hearing, the public hearing on Senate Bill 691. Moving to Senate Bill 718. Senator Roberts, proceed when you are ready.
Good morning, Mr. Chair, members of the committee. I appreciate the opportunity to present Senate Bill 718, which establishes provisions regarding the use of restraints on children in juvenile court proceedings. Currently, Missouri law does not provide a clear and uniform guideline regarding when and how restraints, such as handcuffs, shackles, or other mechanical restraints, may be used on minors appearing in juvenile court. This bill aims to ensure that restraints are only used when necessary for safety and security and not as a default practice. Senate Bill 718 proposes a presumption against the use of restraints on children in court, except in cases where a judge determines that restraints are necessary to prevent harm, flight risk, or disruption. The bill emphasizes individualized determinations rather than blanket policies requiring courts to consider factors such as the child's behavior, past history, and the input of counsel. This legislation aligns Missouri with the best practices recognized by the juvenile justice experts and organizations such as the National Council of Juvenile and Family Court Judges, which advocate for minimizing trauma and upholding the dignity of young defendants. It ensures that children, many of whom may be first-time offenders or victims of circumstance, are treated with fairness while maintaining courtroom security. Senate Bill 718 is a step toward a more just and rehabilitative juvenile justice system, and I welcome discussion on how we can refine this policy to best serve Missouri's youth and our courts. Thank you for your time, and look forward to your questions.
Thank you, Senator Roberts. Is there any questions for the Senator on Senate Bill 718? Seeing none. First witness in support, please come forward on Senate Bill 718.
Mr. Chairman, my name is Daniel Feldman. Thank you for having me, and to the committee members as well. I'm the district defender of the Columbia Children's Defense Team with the Public Defender's Office. We represent children in delinquency proceedings in mid-Missouri. I represented kids in St. Louis and Kansas City before that, and also worked for Children's Division. I'm here in support of this bill because this bill creates the same standard to be used uniformly across the state. The language of the bill is based on standards that already exist but aren't being followed in all courtrooms. So, for some context, in 2017, stakeholders created the Juvenile Officer Performance Standards. These performance standards discuss shackling and say that kids should not be shackled in court unless the juvenile officer, as Senator Roberts mentioned, believes there's a risk of flight or a risk of harm to children or others. And so the reason I'm here today is that currently, whether a child is shackled in Missouri is wholly dependent on which county and courtroom they are on a particular day. The same child in one county, if they were in another county, would be treated totally differently in terms of whether they're shackled or not. This is justice by geography and not fundamental fairness. So what this bill does is it creates a uniform, transparent process for all kids in all courtrooms across the state. Very importantly here, I want to address safety concerns. And a reasonable question would be, how would this bill affect the safety of the courtroom staff, the sheriff, the people responsible for everyone's safety in that courtroom? From a personal perspective, I've represented many kids across the state, charged with delinquencies. I have not seen a situation where someone has been harmed or there has been a risk of harm in a courtroom. In many counties where they currently don't shackle kids, the court has children walk across the courtroom by themselves. Some courtrooms have a sheriff sit directly behind the young person at the table, at counsel table. I gotta say, the counties that aren't shackling children are doing it really, really well. Other states, 40 have eliminated indiscriminate shackling without safety issues, by and large. I have additional information to share about that if anyone would like to inquire. I also want to note that this bill introduced by Senator Roberts doesn't provide for removing shackling in all circumstances. As he mentioned, this is important when discussing public safety and the safety of the courtroom. This bill mirrors the juvenile officer performance standards in that if a juvenile officer is aware of circumstances in which the child presents a risk of harm to everybody in the courtroom or is a flight risk, the juvenile officer, all they have to do is provide notice before a hearing, make the request for the shackles to remain on, and then additional information can be heard. I would add that the bill still gives the sheriff or detention staff the power to transport the child in shackles. Finally, I would just say that this indiscriminate shackling works against the goals of juvenile justice in Missouri. The goal is to assist young people in improving their behavior. And I would thank you, the committee, for their time, and stand for any questions.
Any questions? Seeing none. Thank you for your time today, and we will move further to those in support. Senate Bill 718. Seeing none. Those in opposition? Seeing none. Those for informational purposes? Seeing none. Closing remarks?
Nope. Thank you.
That will conclude the public hearing on Senate Bill 718. Now moving to the last bill, Senate Bill 794. Senator Bratton, the floor is yours.
Thank you, Mr. Chairman, members of the committee. For the record, Senator Rick Bratton, 31st Senatorial District, Cass, Johnson, and Bates, bringing forth Senate Bill 794. So this is a two-part bill. The first portion of this bill basically does a private cause of action for abortion in this state, allowing the injured party or even pro-life organizations for being able to file suit. Given especially the last ruling of Judge Zing, basically making it to where it's impossible for an injured party to seek remedy through our court system. I think it's definitely something that we've got to push back on the courts and ensure that regardless of whatever the medical type procedure being done, that you have a remedy to be able to seek it through a court of law if damages did occur. So that's the first portion of what this would allow for. The second portion would, right now, if something is appealed in terms of something of this nature, it goes towards to the Western District of Court of Appeals. This actually makes it to where Cole County is going to be redirected to where it'd be the Southern District. So I think from what we've seen from the Western District, they've been less than representative of the state of Missouri and the types of people that's the majority of the state are, and I think that this district definitely, I think, emulates more so the sentiment of this state and where we're at politically. And so for that, I'd be happy to answer any questions.
Thank you for your presentation. And are there any questions? Senator May.
Of course,
I was waiting for you because I knew you'd have some questions.
Oh, absolutely. Good morning, Senator.
Good morning. How are you?
I'm good. So I'm looking at, I think it's page 2 of your bill, section 2. So you're talking about, because I'm interested in creating parity, are you saying that any individual who claims to be a pro-life individual can bring a action against an individual who is seeking to have an abortion? Is that what you're saying?
So it's, no, not against. It's against involves a regulation of abortion, or the right of the unborn is at issue. Is basically it allows for the intervention for if they see there's a potential for or a need to intervene in terms of these sorts of policies that allow for them to be able to do that.
Because the way I'm reading it, and maybe we need to work out some language, is that any individual can file a pleading on behalf of an unborn child, no matter who, you know what I'm saying? Mm-hmm. So, I mean, like Joe Blow can over here file a pleading against my unborn child or whatever if I'm seeking to, have an abortion or something like that. And my also concern is, I don't know if it's relevant, but when someone has to have a D&C procedure because of atopic pregnancy and things like that. So I don't know if this is covered in there or removing of the afterbirth after the fetus is out of the womb. So, but anyway, that might not be covered in there, but I'm still concerned of the broadness of this, saying that an individual can bring an action. And if that individual themselves brings an action telling another individual that they can't abort their child, most times when, you're having surrogacy and things like that, people provide financially for that surrogacy. Mm-hmm. So if that individual is not willing to take on the responsibility of the child, pay for the child, raise the child, things like that, I think we should consider all of those things when we're talking about if it reads the way I'm thinking it reads. And well, I think I have to have somebody, to look at that.
Okay.
Senator Gregory.
Yeah, just to comment, I appreciate Senator May's concerns. I do read it differently. I think Senator May is referring to what's called a cause of action. That's when you would initiate a lawsuit. That's a cause of action. When you see the word intervene, an intervention means that a lawsuit's already been filed. So you cannot file one or initiate a cause of action. You can only intervene in a current lawsuit. And it really only relates to, and I think this is your intent, only when that lawsuit is challenging a constitutional right, a Missouri statute, or any other Missouri rule. So it's really just a civil discrepancy on what the law is or should be, whether or not it's constitutional. Your only intent is if that lawsuit's filed, that these pro-life groups have the automatic right to intervene and argue on behalf of life.
Well, you're an attorney, and I'm not, and you put it much better than I could.
No, I'm just making sure that was your intent. That's how I read it, so I just wanted to make sure that was your intent.
Is there any way to make it stronger? I mean, any way to make it like, you know,
We can make this bill
clear.
stronger.
I'm talking about
clear,
clearer,
okay.
you know, in reference to what you just said, because to me, you know, we have unintended consequences by legislation. So you're saying that cause of action, you give me, you know, maybe we'll say the pro-life individual organization may intervene in any action in which provisions of the Constitution of Missouri, Missouri statute, any Missouri rule that involves regulation of abortion or where rights of an unborn child is at issue.
That's right.
So the rights of an unborn child, you get what I'm saying?
I do think it's pretty clear.
Well, that's because you know, you're reading it as in.
Yeah, sure.
So
Yeah.
we should say not referencing cause of action. We'll talk about it off.
Okay. Any further discussion? Seeing none, first witness in support, please come forward.
Thank you, Mr. Chairman, members of the committee. Samuel Lee with Campaign Life Missouri to go on record in support of Senate Bill 794. We thank Senator Bratton for filing this. And yes, I think, Senator Gregory, your interpretation is exactly correct. You could write this, use more words, and you could say any pro-life individual or organization may intervene, and it's only intervening in an action that already exists, in any action in which a provision of the Constitution of Missouri, et cetera, that involves the regulation of abortion, period. And then you could also say any pro-life individual or organization may intervene in a cause of action dealing with the Constitution or regulation where the rights of an unborn child is at issue. So, for instance, on that latter example, we have Section 1.205 passed in 1986. It declares that the rights of the unborn child shall be the same as any other person, rights, privileges, and immunities. If Planned Parenthood, for instance, were to file a lawsuit saying, under Amendment 3, unborn children no longer have rights, okay, unborn children aren't persons, Amendment 3 overdid that, then a pro-life individual or a pro-life organization would have a right to intervene. Okay, now, that doesn't mean 100 pro-life individuals or 100 pro-life organizations, because only the first one that would do that. And why that's important to put that in statute is because our statute controls who can intervene. It's in Chapter 507, specifically Section 507.090. Upon timely application, anyone shall be permitted to intervene in an action when a statute confers an unconditional right to intervene. There is no unconditional right to intervene right now. Now, this isn't to say that the Attorney General hasn't been doing an outstanding job of defending our laws. But there may be different Attorney Generals in the future. There may be certain legal arguments that it's not appropriate for the Attorney General who would be representing, let's say, the Secretary of State in an action or a statute to raise where someone who intervenes would be the more appropriate person. So we support that, and of course we support the authority that the legislature, your exclusive authority, to determine the boundaries of the courts of appeal. That's not controlled by the Constitution. The Constitution says you have to have a minimum of 3 Court of Appeals districts. You could put by statute, you could have a dozen if you wanted to. Each one has to have a minimum of 3 judges. You can't have less. But by statute, as cited in here, the legislature determines what counties are in which Court of Appeals districts, and this simply moves Miller and Cole County, which are very close to the Southern District. It's interesting, if Cole County would be in the Southern District, and of course the cases would be heard in Springfield, Cole County is actually closer to Springfield than it is to Kansas City. So you'd actually save time and money by moving it to the Southern District and to Springfield. Happy to answer any questions.
Senator May.
And lastly, reducing the number of judges in the Western District makes sense because their workload would decrease, because all these state cases and administrative hearing cases would be going to the Southern District, and this would give an opportunity for Governor Kehoe to appoint some good judges on the Court of Appeals in the Southern District.
Senator May.
Are you saying there are not any good judges on the Southern District?
Oh, I think there's some good judges on the Southern District. This would give them more good judges on the Southern District because their workload would increase. And as the Attorney General or as parties would be, who had a case in Cole County, would drive, it'd be less of a drive than to Kansas City, would go down there. You'd have more judges who could hear these cases and
Or
dispose
is
of
it
them.
just it's a more favorable jurisdiction?
Well, I
to the cause?
think we're talking about fairness and judges who make good rulings, and it's absolutely clear that the Western District Court of Appeals did a terrible job when they rewrote the ballot summary language for Amendment 3. They just got it wrong.
That's opinion, right?
Well, it's an opinion, but it's being held out, it's being proven by the lawsuit that Planned Parenthood filed within hours after Amendment 3 was approved by the voters.
Okay, so let's get back to the bill. So the only question I have is, when we're talking about, I'm still concerned when we say should you be able, an individual should be able to intervene. And I think we need a distinction when we say, you say individual or organization. So the individual part is my concern, especially if they don't have legal standing.
This bill gives them legal standing to intervene.
I know, but you're giving them legal standing, and are we just talking about, if it's an individual, if it's another individual who they're coming against?
This doesn't apply to that. This has to do with actions where the Constitution of Missouri, a Missouri statute or a Missouri rule, an administrative rule of some sort, is challenged. This has nothing to do with an individual.
We need to add that clarity.
Well, Senator, it is clear on lines 27 and 28. It's only those types of cases. It's not cases where a woman goes to court to get an abortion. That's not the case here. I mean, I don't know how it can be any clearer than what it says.
Okay, I understand it's not about a woman going to court to have an abortion, but most provisions that even get to court is in reference to some other cause of action, just like Roe versus Wade was about an individual. That's how it got to the Supreme Court in the first place, because it was an individual.
Okay.
Case. You
Right.
you follow what
Sure,
I'm saying?
sure.
So individual cases involving individuals do get there. So all I'm trying to say is, I guess I'll figure out the wording and we'll have a conversation about the wording.
Happy to
because
have.
I'm just talking
right.
about, legal standing in certain instances. So,
Yeah.
and I'll have to paint a clearer picture, I guess, because I don't want you to think I don't understand what it's
Sure.
saying, but we're
Sure.
just not communicating what I see that's not there.
I understand, Senator.
Okay,
Thank you.
Thank you.
Seeing no further discussion, we're going to move to the next in support. Next witness in support, Senate Bill 794.
Good morning, Mr. Chairman, members of the committee. For the record, Susan Klein, representing Missouri Right to Life, here to go on record in support of Senate Bill 794. In our discussion with my attorneys, obviously we came to the same conclusion as Senator Gregory and the previous witness. Oftentimes whenever we talk about the preborn, we're talking about a baby that has no voice. We support this bill because we believe that it gives us, as individuals, the opportunity, and even the pro-life OBGYNs that were here last week whenever we were talking about the issues in the legislature on life issues. And it would give them an opportunity, as well as any other individual who's very knowledgeable of the pro-life issues, to have a voice when we were talking about either the Constitution or a Missouri statute. So we strongly support this bill and thank the sponsor for bringing it forward.
Any questions? Seeing none. Moving to the next witness in support of Senate Bill 794.
Good morning, Mr. Chairman, members of the committee. My name is Arnie C., AC Dinos, State Public Advocate. I'm in support of SB 794. This allows for bringing action in county circuit court on behalf of an unborn child and challenging state constitutional provisions. I believe that this shall apply to any organization that has a standing or a feeling about unborn children. Our goal here is to abolish any abortion in our state and make sure that life, the sanctity of life, is adhered to. So this should apply to any organization and also any Missouri citizen. I believe this is very strongly. I believe that any Missouri citizen also has a standing in terms of an unborn child. This bill also realigns the appellate court of Cole County and Miller County from the Western District to the Southern District. This aligns the Western District from 11 appellate judges to 7 appellate judges, and the Southern District from 7 appellate judges to 10 appellate judges, saving taxpayers the cost of a judge, clerk, paralegal, with salaries, benefits, and pension. The fiscal note savings for 2026, a net gain for our general fund, or the court judicial fund appropriations bill, is $1.7 million. 2027, it would increase to $2 million. 2028, it would remain at $2 million thereon for succeeding fiscal years. It affects 13 full-time employees, and I agree with this move. I think it's a good realignment for our state. I believe it would be more conducive to appellants and would save appellants travel time, travel expenses, gasoline, etc., by realigning this appellate district. Overall, this bill gives every person shall have the legal standing on the issue to file and initiate a lawsuit in county circuit court. For those reasons, I support SB 794.
Thank you for your testimony. Seeing no questions.
I also submitted my form online with the other bills for this morning, so thank you.
Perfect. All right, moving to the next witness in support. Any further witnesses in support? Seeing none. Any in opposition? Seeing none. Any for informational purposes? Seeing none. Closing remarks.
Thank you for the hearing.
All right, that will conclude the public hearing on Senate Bill 794. Having no further business before the committee, we are now adjourned.